Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to talk about an application brought by a plaintiff in respect of their role as a former employee of a company. Right, let's set the table and figure out what all the players are involved in this one are. So we've got a company. The company operates a business. That business sells mined diamonds, lab-grown diamonds, and jewellery, right? It's a diamond selling business. That business has 4 directors. Each of them are natural persons, real flesh and blood. And that business has 4 shareholders. Each of them are companies or other entities controlled by or related to each of those 4 directors. So person A, who is a director, has company or entity A, who is a shareholder, and they're related to each other. What happens is our plaintiff today, the person who's bringing the application to court, the person who's suing, who we're about to talk about, they are a senior employee of this company. They're the CEO. And another of the plaintiffs, who's also the sibling of that plaintiff, is the sales director of the company. And they're bringing the application today because they were terminated. Now, the CEO is person A, if we use that example before. So person A, that CEO, is a director of the diamond selling company, and entity A, that's person A's or our plaintiff's company, is the shareholder. The nature of the application today is that our plaintiffs say our termination, the end of our employment as CEO for first plaintiff and as sales director for the other plaintiff, was a breach of the corporate oppression elements of the Corporations Act, and so we should get an immediate interlocutory injunction. We should get orders right now that reinstate us back in our position as CEO, back in our position as sales director. They want this interlocutory immediate relief today, and then final relief at the end of the dispute. What they want is a buyout. They want an order that the entity A's shares and also the siblings entity's shares are bought out for fair value at the end of the litigation. Now, what's interesting is that when the court is considering interlocutory orders of this kind, there are 2 basic issues that the court needs to balance up. Question 1 is there a serious question to be tried? Is there a prima facie case in favour of what the applicants for the interlocutory injunction are after? And the second great big question is, where does the balance of convenience lie? Is it more convenient? Does the balance of the convenience lie in favour of making these interlocutory orders, which are sometimes quite violent and sometimes really affect the rights of other people? Or does the balance of convenience lie in favour of a monetary order, essentially ordering some monetary damages at some stage later at the end of the litigation? That's what the court is left to consider today. But let me just give you a few more facts. So over time, the CEO is managing this diamond company and reporting regularly to the directors in the normal course. In 21-22, there's some success undertaken for the business, but by the time we get to late 23, sadly there's been a bit of a slackening of the financial performance, and there's a board meeting in late 23 where a resolution is passed by the board that the salary of the CEO is reduced by 11%, and it's during that meeting that our plaintiff sort of shares the view that perhaps we're not perfectly placed to be in business together forever. There's an undercurrent of a bit of a disagreement there. Sometime after that meeting, the plaintiff, along with the plaintiff's sibling, or as a representative of the plaintiff's sibling too, makes an offer to sell their shares and to essentially exit the company, exit the structure. Now there's a reply made on behalf, or apparently on behalf of the other 3 directors and their 3 entities, that essentially says, look, it's December 23 now, we'll get you a reply in January 24. There's no reply in January 24 that the court's made aware of, nor Feb, nor March, nor April. And in early April 2024, there is a letter issued directly to our plaintiff CEO and to our plaintiff sales director purporting to effect immediately the termination of their employment. Kaput, they are done as employees of the company in their role as CEO and in their role as sales director. Today's application is all about whether they can get their injunction, their interlocutory relief, to force the company to reinstate them in their previous position as CEO and as sales director. Now, in order to consider that first question we mentioned before, is there a serious question to be tried, the court had to consider the nature of the relationship that particularly the plaintiff CEO had with the company. Now, this relationship was governed by a couple of documents. The first document was what's called a terms sheet, and that sort of dictated the way shareholders and directors interacted with each other and the sorts of decisions that will be made at board level, the sorts of times when certain types of voting would be appropriate, and the various decision-making and meeting processes. And elements of that term sheet suggested that for serious decisions like opening or closing a business in a certain area or a certain city, and the employment or termination of employment of senior employees would be board level decisions. They'd be decisions that the directors would need to come together on. The second agreement that governed the plaintiff's relationship with the company was an employment agreement. And that was the basis, it does what it says on the tin, the employment agreement. That was the basis upon which the plaintiff was employed as CEO. And as part of that agreement, there were some pretty broad and pretty brutal, on one view, circumstances in which the company could terminate the employment of the plaintiff as CEO. So on the one hand, the terms sheet says the board has to come together to make decisions, including for senior employees. I think you know where we're going with this. Then on the other hand, there's an employment agreement that gives the company pretty broad power to end the plaintiff's employment as CEO. The question the court has to ask itself is there a serious question to be tried here? The short answer is that the court finds yes. The termination of the CEO's employment looks like there's a serious question, there's a real issue, a real dispute here as to whether that termination was essentially in breach of the terms sheet, in breach of the basis on which the company is run, because that decision was made in the absence of the plaintiff, apparently in breach of the terms sheet. What the judge goes on to say is, yeah, look, there is a serious question, there is a real issue, but, or in addition to that, there's this issue about, well, the company does have pretty broad powers to terminate the employment. And so there's a question here about whether there is indeed, or whether indeed the plaintiff would be able to prove that it was oppressive that they were removed from their role, especially where the plaintiff has granted, pardon me, such broad powers to the company to end their employment pursuant to the employment agreement. But in any case, that's a tick for serious question to be tried. The next issue, as you'll recall, is the balance of convenience point. And the court is left to ponder, well, all right, if there is a serious question to be tried, are we going to order this interlocutory relief? Does the balance of convenience test, does it meet that? And so the court must turn its mind to a number of factors. And there are sort of 4 points where the court finds that no, we don't meet the balance of convenience test. First point is the court notes the difference between the interlocutory relief, says, well, the interlocutory relief, the relief you want right now, is reinstatement. And the final relief, the relief you want at the very end of the litigation in 6 months, 12 months, 18 months' time, is for your shares to be sold, your entity's shares to be sold. Essentially, you're looking to end the relationship at the end of the litigation, but right now you want to rejoin the company and be reinstated. And so the court says, there's a bit of a mismatch here between the interlocutory relief right now you want and then the share sale, the exit sort of relief you want later. And the court says, well, probably the balance of convenience weighs against you on that point. Secondly, when considering the balance of convenience, the court often asks itself, well, are damages enough? Is payment of money at the end of the dispute enough to put the plaintiff right so that we don't need to order this violent interlocutory relief right now? And the court sort of says, well, in relation to what we might think of as an inappropriate termination, I won't use the term unfair dismissal because that doesn't arise in this case, and it's not that particular type of exit. But, you know, on the surface of a sort of unfair end to employment, if I can frame it that way, the court says, look, damages probably would be appropriate. The court also goes on to say, if there is a share sale at the end, if there is an order for a buyout made by the court, then that buyout order will include in the calculation of fair value of the shares an amount for the oppressive conduct. And so the plaintiff is going to be put right either by the payment of money in relation for the unfair exit or either by, or by both of, a payment of money, potentially, for the unfair exit, and secondly, accounting for the oppressive conduct in relation to the value of the shares. So it looks like money will be enough to put the plaintiff right. So the balance of convenience weighs against the plaintiffs a bit in that circumstance. The third factor that the court turns to in relation to the balance of convenience is about the maintenance of the status quo. What the plaintiffs say is, I'll put us back into the company in order to maintain the status quo. And what the court says is, well, that's not quite right. The status quo is that both plaintiffs have been fired. You're not performing your CEO role, and there's a new person doing that task. You, the other plaintiff, is not performing your sales director role. There's another person doing that task. There's been an industry publication and people have been notified that you're gone. The Sydney office that we infer the plaintiffs used to work in has been closed. And so if we were to force the company to reopen the Sydney office, force the company to re-employ you, essentially we'd be taking this status quo where we've got people performing your role and we'd be upsetting the status quo. And so the suggestion that reinstating you over the top of the existing position would be maintaining the status quo is wrong, because what it would be in effect doing is upsetting the existing status quo. And so that weighed against the balance of convenience. And fourthly, the court noted that in matters of this type, generally speaking, the court is going to be reluctant to order interlocutory relief. And if you and I are discussing this together, we can understand that makes sense, because we have the expression of the will of the majority of the shareholders, the majority of the board. Those majority of shareholders, majority of the board have said, we don't like plaintiffs 1 and 2 anymore, we want them gone. And a court is generally going to be reluctant to say, well, most of the directors and most of the shareholders have said we want them gone. We're going to be reluctant. The court's going to be reluctant to force back into the company people who the majority have already said they want gone. And so that sort of weighs against the balance of convenience test. And so what we have here is our plaintiffs failing in their application to be reinstated in their roles as CEO and sales director. They're then left to fight another day in relation to an argument about the buyout of their shares, but that disposes of their application for an interlocutory injunction. I hope that discussion assisted you, and I look forward to chatting again soon over another coffee and in respect of another case note. Cheers.